Welcome to No Disputing That, the go-to podcast for all things mediation, arbitration and alternative dispute resolution. I'm your host, Gregory Hunt, here to bring you expert insights and engaging conversations with leading professionals shaping the future of ADR. Whether you're navigating the field or just curious, this podcast will sharpen your understanding and challenge your perspective. Ready? Let's get started.
This episode is sponsored by Business AI Studio. Are you looking for a smarter way to create professional video content? With Business AI Studio, you can generate engaging, high-quality videos using AI avatars. Perfect for boosting your business presence, simplifying legal concepts, onboarding staff, or delivering training on demand. It's fast, cost-effective, and scalable for businesses of all sizes. Visit ai-avatars.io to learn more.
Welcome to this episode of No Disputing That. Today I'm joined by the ever-impressive Kelly Thornton, who is on the Hunt ADR training faculty and one of our recent graduates on the Hunt ADR mediator training course, Cam Wareham. Over to Kelly first. Kelly was called to the bar in 2016, the same year she qualified as a CMC accredited civil and commercial mediator. She expanded her mediation practice to include workplace mediation in 2017. Kelly has experience as a travel mediator and is a member of numerous mediation panels, including those operated by Hunt ADR. Since 2019, Kelly's been a member of the Hunt ADR mediator training faculty and has delivered the 40-hour civil and commercial mediation training course to professionals and university students online and in person. Kelly's heavily involved in the expansion of the Hunt ADR training offering and works closely with the rest of faculty to expand and improve our training programs. Kelly is a vital cog in the Hunt ADR mediator training machinery. In addition to her role at Hunt ADR, Kelly serves as a lecturer and academic at the Global Banking School, and she's a legal consultant at Wainwright and Cummings LLP in London. Hi, Kelly.
Hi.
Thank you. And Cam is an international arbitrator, a CMC registered mediator, trained and accredited by Hunt ADR. He works primarily from his London-based chambers. He holds a part-time professional position at the University of Sunderland School of Law. Cam's background, like him, is a little unique. He's previously been a practicing NHS surgeon, and this has meant he's had to listen to my tales of woe about my knees in great detail at various times since we've known each other. He's been a sub-dean in a university medical school in Australia and has sat on a number of Department of Health committees, regulatory tribunals and Royal College boards before requalifying in law from the University of Aberdeen. Cam has vast experience in the health and life science biotechnology sector and concentrates his activities around medical law and dispute resolution. Although Cam's been in the UK for almost 30 years, he still considers himself an international citizen, having lived and worked in the UK, Australia, and being born, bred, and educated from New Zealand. Hi, Cam.
Hi, how are you?
Good, thank you.
Good.
Well, it's good to see you both back again. First time on No Disputing That, but we spent many hours on Zooms in the past, particularly during the mediator training week. One main reason for us having this conversation today is there's been some changes to the CPR rules, which came into effect on the 1st of October, and have led to the power for the courts to be able to compel ADR. There's a lot of conversation around this at the moment, a lot of differences of opinion on what this is going to mean in practice. So I thought it was a good idea, knowing that you two have got very, shall I say, pointed opinions on this topic. I thought it'd be a good idea to get you together and run through some of those views so that other people can benefit from your knowledge and experience and thought. So Cam, let's go over to you and see what your initial comments are.
Thanks, Greg. Look, I think the changes to the civil procedure rules have perhaps clarified things a little bit more than anything else, and now having the decision in Churchill being clarified, then I think that the CPR rules are now enable courts to take a different approach to dispute resolution. So I certainly see that as a benefit, and we see that primarily in the first section, which is looking at promoting the use of alternative dispute resolution and enforcing compliance with those rules. So at this point, I think it's a very positive move, and I'm really pleased to see that it's come into play. I don't know, Kelly, what's your view on things?
I agree. It's definitely a positive move. My main concern is that people will take this as a green flag for mandatory mediation, which it definitely isn't. So I think it's worth bearing in mind that what specifically has changed here that's sparked the conversation more broadly in the media is the fact that we used to say that parties would be encouraged to attempt ADR procedures before they litigate in the civil justice system. That's now been replaced with the words ordering and encouraging, which isn't a huge change, but it's this idea that courts will explicitly need to decide whether they can order parties to attempt an ADR process. And if they unreasonably refuse, we have the same cost orders as before. But it is not saying that you absolutely have to mediate or you have to do an ADR process and you have to settle out of court. You still have the same access to the civil justice system as before.
Okay, so
Yeah.
many of the people who listen to this podcast, and myself included, are not lawyers. And of course, this is about a change to the CPR rules. It's about going to court and what the courts are going to order or suggest or promote. What does that actually mean to someone who isn't a lawyer, who is maybe embarking on a dispute that looks like it's going to go to court, or you're a mediator and you're maybe thinking that you really need to be aware of what's going on here in case it comes up in a mediation and you're asked a question by a party, whatever it might be. What put it into real layman's terms about what these changes mean?
I suspect the takeaway message from all of this is that mediation as one form of alternative dispute resolution, and we ought to put at this junction that there are others as well, but is to be looked upon as a good opportunity to try and settle things at an early opportunity, rather than simply running the case to court in front of a judge. And I think the realities are that the court now expects us through the civil procedure rules to start managing cases effectively and try and divert them to settlement where possible. So rather than it being a added extra nice to have, or we'll see if we can try mediate, it's a little bit more of an expectation that parties will come together with a realistic attitude towards trying to settle the differences, and rather than simply parking the decision with the judge. That's my takeaway, and perhaps there's a little bit more of a shall we say, an incentive to reach the settlement agreements where we can. And that's in the form of a costs order, which the courts can now empowered to order against parties if they unreasonably refuse to mediate or unreasonably refuse to enter into dispute resolution.
I completely agree. I think the key thing that Cam said there is expectation. So it's not mandated, but it's built into the civil procedure rules, which dictate how we conduct civil procedure in the UK, how you bring civil cases in the UK. It's now built into the actual system itself that courts can order mediation, they can order you to attempt ADR, and they have to explicitly consider whether to make those orders and how to encourage parties to engage in ADR throughout the process, which obviously would include mediation. And as Cam referenced there, failure to comply with that order for ADR or an unreasonable refusal to even attempt an ADR process can be punished in terms of cost orders. So parties who fail to try any form of ADR process and try and run straight to court, straight in front of a judge, will have to justify their actions to the court, or they potentially risk cost penalties regardless of the outcome of the actual case. So I think the point here is the power to order ADR isn't going to be some blanket power that judges do in every case. It's empowering the judges to have that option. And as Cam said, to kind of encourage this culture where most cases are resolved through dispute resolution rather than everyone seeing the court as the first port of call.
I think that's a very important point that Kelly raises, and perhaps it might be worthwhile at this juncture just touching on the reasons we find ourselves in this position. And I think most people in the dispute resolution field will understand the terms or heard of the terms of the Churchill case. And the Churchill case was a clarification on the earlier Halsey case, which we've had for nearly 20 years now. And that, I think, typified the view of the courts of trying to encourage dispute resolution. When we look at Churchill, we see a claimant who was very perhaps motivated towards running to court, wasn't particularly interested in engaging in dispute resolution at all, and rather unreasonably decided that they would not engage in any of the processes that had been put together by the respondent, who was the counsel, in trying to resolve the issues. And part of that process was about saying, well, has this person got a reasonable reason to refuse mediation? And in his case, he suggested that it breached his Article 6 rights, human rights, right to a fair trial. But I think that it's important to realize that the court held that it wasn't going to be a breach. And actually what they did was not mandate mediation, which Kelly's alluded to. What they did was they suggested that you must enter into a form of dispute resolution, and that is something that the court can impose if they wish to. But it doesn't take away from the abilities of the ability of the party to agree or not agree. They still own the outcome of mediation or dispute resolution, but they can be encouraged to attend it. And I think that's very important, that we understand the reasons behind the decision in Churchill and how that has changed the landscape or changed the view, that we can now be forcibly or encouraged to go to mediation, but we still own the outcome. Kelly, would you agree with that summation?
Yeah, sorry, I think completely. I think the key thing with Churchill is it wasn't a overturning of Halsey saying that suddenly everyone has to mediate, everyone has to do ADR. What I think the court were trying to do was really show that the courts do possess an inherent power to stay proceedings or order parties to engage in ADR processes, obviously including mediation. And that's still subject to the normal caveats. You still have a right to fair trial. You still have the option to go to court. It doesn't prevent you having access to the justice system. It's about promoting ADR as a kind of fair, quick, cost-effective resolution, which, as Cam said, is still owned by the parties. It's the voluntariness and the ability to take control of your dispute that people like when they go to ADR processes in the first place. And all the court was doing there was really emphasising that that is a good option, particularly with things like COVID backlogs and the current pressure on the civil justice system. And it's known that the Churchill decision prompted the redrafting of the CPR rules. So it's a wider cultural shift to deal with civil justice in a more practical way that empowers the parties to resolve their disputes in a method that suits them, rather than the default position be going to court.
I think that's a very good summary, and I like the fact that reasonableness has been mentioned quite frequently throughout a lot of the decision making in this, and it is about really whether people are reasonably trying to resolve their differences, and that's where I see the benefit of mediation moving forward. And certainly with the CPR changes, we now see that there are available options for the court to encourage people, including putting cost sanctions against them. And we see that in one of the later cases earlier in this year. And that was the Northumberland case. And in that case, it's very interesting because at appeal, the court held that simply remaining silent to the request for mediation is not a valid defense. You can't simply just ignore the fact that someone has mediated. And importantly, what they found in that case was the fact that actually the claimant had offered the opportunity to settle at mediation. And that simply wasn't responded to. So a costs order was put against the respondent because of the fact that they simply remained silent and they didn't engage at all. And it's nice to see these things becoming clarified more and more as time goes on, post-Churchill.
I think that, I mean, obviously that's a great case to have come out recently to show how this is developing, and it's the kind of case that obviously UK legal professionals need to be paying attention to. But I think there is a shift towards parties and their legal representatives being put in the position where they're supposed to be promoting ADR as a core dispute resolution method. As you said, not just ignoring requests and using silence to be sort of tacitly complicit with going to court. So this, I think, overlaps with the new powers and responsibilities for the courts in the CPR amendments that came into force 1st of October 2024. And I think it will be interesting to see the sort of ongoing developments, this move towards a case-by-case approach and how it might impact different areas of litigation. And as Cam said, this clarity is starting to come through, that we're focused on reasonableness, we're focused on empowering parties to take control of their dispute and use ADR in a way that will be tailored to their individual disputes, rather than seeing court as the sort of one-size-fits-all solution for any civil case in the UK.
Well, that leads a question from me then, I think, which is, we talk a lot about mediation and the effect this has on mediation, and the word settlement and parties being in control of the settlement themselves has been mentioned a few times. But what about arbitration?
My feeling is that it's quite telling that arbitration has been left out of it. In fact, it's not mentioned in any of the civil procedure rules, and it's not mentioned in any of the case analysis either. Expert determination or early neutral evaluation is mentioned, but actually arbitration has been set aside. And I wonder, partly because that has its own legislative structure. The Arbitration Act 1996 speaks to arbitration, and it's seen very much as a semi-judicial way of resolving disputes. I think mediation holds a different value in a different place. Whilst arbitration still remains very, very helpful and very important for certain types of disputes, certainly in my experience at least, mediation is perhaps more applicable to many of the cases which would come in the fast track arena. Kelly, I don't know what your views are.
I agree. I think obviously the CPR rules refer to ADR quite broadly, and so in theory that does include arbitration. But as you said, given they have their own legislative scheme, arbitration's already quite regulated. I think this will be really interesting for wider ADR professionals, whether they do expert determination or conciliation and mediation, because this really is an opportunity to be more involved in the civil justice system. There'll be lots of increased demand, lots of career opportunities as courts start ordering parties to consider mediation. And I think it'll be interesting to see how mediators specifically adapt and sort of do professional development to deal with those influx of cases. And of course, it's probably worth mentioning, especially to the audience for this podcast, the ethical considerations and the challenges relating to this. So as the use of ordered mediation grows, ADR professionals will need to be particularly mindful of like the ethical considerations surrounding power imbalances, ensuring fair outcomes, ensuring that parties understand that they have the option to go to court, but there are consequences if they have a completely unreasonable refusal to attempt their mediation or their other ADR process. And I think it's quite an exciting time to be a mediator, because it will be our job as mediators to maintain the integrity of mediation as a voluntary and collaborative process where parties own their disputes. And given that the civil procedure rules are now adapting and the justice system's taking ADR even more seriously, mediators and other ADR professionals will have that opportunity to influence policy and practice and promote the values of ADR, which hopefully is why we all went into this sector in the first place. But I think that's definitely something for audience members to be, or listeners to be, considering as they develop their mediation and other ADR practices.
And I think it's important, just to go back, Kelly, and Greg, to go back to the issues about what is mandatory mediation versus it's not mandatory at all. It's about compelling people to attempt to settle things, But just to reiterate again, as previously mentioned, that the outcomes remain with the parties. So it's not really an issue of mandatory mediation per se, or perhaps it's more nuanced than that. It's the outcome that still remains with the parties, even if they are encouraged, and we can say it that way, encouraged to go to mediation or try alternative dispute resolution. They still own and they still are empowered to scope the outcome.
I completely agree. I think the key point there is that it's the ability to order ADR, not order a settlement. So the
Correct.
orders
Yeah.
from courts will be in order to go and attempt an ADR process that would be suitable for the dispute, rather than a mandatory order to go and settle at an ADR process. And I think that nuance is getting lost in the wider media debate at the moment.
I think so. I think you're right. I mean, and certainly from my area, I don't know about whether you have any comments on your area, but my interest area is healthcare, biotech, and life sciences, and we see mediation being used quite extensively. Certainly now within the NHS resolution schemes, it's grown in size. It's grown in its capacity to offer an alternative to traditional court proceedings, whereby parties can talk about what it is that brings them to mediation, and they can talk about their concerns and try and arrive at a reasonable settlement that works for everyone. So I'm quite encouraged. I see these changes as being very helpful to put mediation forward, and I quite like the way that even if it's not mentioned in the cases, that it's been put forward as being a dispute resolution tool rather than alternative. I've never been comfortable with the alternative tag. I don't know. There's been other terms, but really the point is to make sure that mediation, dispute resolution, arbitration, or whatever tool you want to use remains at the forefront as a way of resolving things, and actually perhaps litigation is put to the back of the queue.
But I completely agree. I'm very encouraged by it. From a commercial side, in terms of complex commercial litigation, we see parties that are pretty inclined towards ADR anyway because of protecting brand image, not having to pay thousands of pounds worth of court fees and wait through huge backlogs in court proceedings to wait for their trial dates. But I think the amendments will serve to encourage that earlier in the process, and also to give that extra push to parties that aren't as sure about ADR or aren't as familiar with what ADR is. And in the lower value claims, the courts will probably, my guess would be, will be more inclined to utilise the new powers to alleviate the burden on the court system, particularly for those small claims track or fast track cases that aren't particularly legally complicated. My other area is in family law. So we've got a slightly different system over in family, where there's compulsory mediation information assessment meetings. They've been in place since 2014. They've been working very effectively. But again, it's not mandatory mediation. It's a mandatory meeting with a mediator who discusses with family clients or family parties why mediation would help with their dispute, and then they make a choice about whether they mediate or not. So I think family is already a bit more regulated. They've got a bit more of a system in place, and obviously the Family Mediation Council tightly regulate family mediators. In the next decade or so, I imagine a similar system will happen in civil mediation. But I think it's going to be very useful for commercial parties and small claims civil parties.
I think that's a good point. I mean, you're talking about the MIAM meetings, aren't you? And I wonder whether those will be, as you say, moved across, or a model adopted for the civil and commercial sectors. One interesting thing for me that I've noticed in the past is the tick box approach to mediation, which I would like to see consigned to the dustbin, if I'm honest. And that is where perhaps the mediator is not involved, but yet there's a nod to mediation or nod to dispute resolution, and those sometimes are case conference meetings or joint settlement meetings where perhaps the parties are not involved in any of those discussions or outcomes at all. But it seems to be that they have been used in lieu of mediation. Kelly, have you got a view on that at all?
Yeah, I agree. They're definitely used in quite frequently used in lieu of mediation, and I would hope that we move away from this tick box kind of culture towards balancing this idea of not quite compelling mediation or ADR, but strongly suggesting it and still maintaining the autonomy of the parties. Because I think what's important here is we don't see this as just another box to tick on the way to court. It needs to be a cultural change towards empowering the parties further to look at ADR and different ADR methodologies to resolve their dispute, rather than seeing the court as the only way to resolve the dispute. And that is happening, and it will hopefully continue to happen, but there will inevitably be concerns that this is just another tick box on the way to your 2-year waiting list for a court trial. So I sincerely hope that doesn't happen, but I don't think it will. I think the reason they're being subtle with those changes and they're empowering the judiciary first is because they want to, from a top-down point of view, start encouraging that cultural shift towards empowering parties to resolve their disputes and dealing with the kind of implementation of more widespread ordered mediations, and deal with court backlogs, lack of legal aid within the civil justice system, those kind of practical things that are actually burdening the system at the moment. It's not another hurdle for no reason.
Yeah. And it was good to see that, as I mentioned before, the Northumbria case really displayed that quite nicely, that they are encouraging people to just resolve their disputes, and there is a way that the courts um, can can put a penalty to people who are simply recalcitrant to engage.
And just for clarity as well, we're talking here at the moment about claims up to £10,000.
Yeah.
Yeah,
Yeah.
it's important just for listeners. These new changes are for claims up to £10,000.
Correct.
Just to clarify, there are two systems. As far as I know, claims up to £10,000, so small claims tracks, they will be ordered to attempt ADR, and they will only be allowed to bring the claim, as in launch the litigation, once they've attempted ADR and it's failed. Above £10,000 is where you've got the option for courts now to order ADR rather than just suggest or encourage ADR. So it will affect all cases, but it's closer to mandatory mediation for the small claims track under 10,000. It's still not mandatory mediation because of what Cam and I said earlier, in terms of it's not that you're ordered to settle, you're ordered to attempt ADR and come back basically if the ADR fails, and then you can launch the litigation. So in that sense, it's another procedural step being put in place. With the small claims track thing, I think the key thing is we don't want to mislead people that it only applies to small claims.
Yeah.
No, I was just going to say that.
Claims. Yeah. Sorry. Go on.
No, I was just going to say exactly the same. The difference is, well, the multi-track claims will have to consider things at a case management conference hearing, where ADR can be imposed by the courts if they need to. So that's the distinction. That one is actually already ensconced in the scheme as it is, and one will have to consider ADR as a diversionary tactic at the case management conference.
Yeah. Okay.
Yeah. Whereas small claims track, it will be before the claim's been issued.
Absolutely.
It will be assumed that there will be ADR at least attempted, and then if it's failed, then you'll be able to issue your claim form in the small claims track.
That's absolutely perfect. That's a very good clarification. So the courts won't even see anything with the ADR. They will have assumed it's already taken place and failed at that point before they come to the small claims
Will that
track.
largely be through the small claims telephone mediation service?
So the Ministry of Justice have agreed to fund 1 hour of free telephone mediation for all small claims track cases. That's been put in. That's partly what sparked this debate about whether it's mandatory mediation, but it's the mandating of attempting ADR. And then for multi-track and fast-track cases, as Cam said, it's built in once the litigation's on foot at the CMC, where the court now has the power to order ADR. But again, it's ordering engagement with ADR, not ordering you to settle during an ADR process.
And it is reviewing the whole host of tools and options, which is perhaps why it's been helpful that actually they haven't really mentioned one specific form of ADR on a fairly consistent basis. They've spoken to mediation, they've spoken to E&E, but they haven't mandated a particular type, because not every single case is going to be suitable for one form of ADR. There will be multiple different forms of ADR which might be suitable in different areas. So I think that that's an important thing, that to understand that the toolbox is presented for us, which we can choose from. So again, it scotches this idea that everything is mandated. The whole anxiety around mandated mediation really is a bit of a fallacy.
Absolutely agree. I think the other thing to bear in mind is legal professionals should already know about ADR. It's already built into, for example, the bar exams in the UK. But
Yeah.
there'll be more pressure now to really look at your client's dispute, what different options there are for ADR, what's available in your area, and move from there. And from the ADR professional point of view, bearing in mind that it's now more built into the civil justice system, you can expect more small claims. You can expect to need to develop professionally, maybe go into new areas of specialism as demand grows. So
Yeah.
that should move that cultural shift towards, as you said earlier, dispute resolution rather than alternative dispute resolution.
Mhm.
And,
Okay.
and it's interesting, Kelly, that you mentioned about the bar exam. It's also in the SQE exams as well. There's quite a chunky section on dispute resolution, which is what we would classify as alternative dispute resolution, in addition to traditional litigation. Um, and I think we are seeing things move as we speak. We're seeing many more claim forms, or heads of claim forms coming through with the option to mediate or to attend a form of dispute resolution. It's whether the legal professionals take note of those, and whether they properly and fairly assess that their client's interest may be best served by resolving the dispute at an earlier phase, or an earlier stage in that phase. And that's where we see the recent cases come through, and speaking to the expectations of the court, that will be done, rather than just a ignorant or ignorance of that particular request.
I agree. I think to some extent we can rest easy because all the newly qualified solicitors and barristers are forced through ADR processes in their education, much to
Yeah.
their delight, because I'm sure that especially legal aid lawyers are very impressed with the ability to add another string to their bow and potentially set up their own ADR practices, but it is built into the education system. So over the next few years, it will filter through that all lawyers will understand it, and hopefully we'll catch some of the more experienced lawyers who didn't have it built into their qualification process with the new court hearings, new court judgments, and these changes to the civil procedure rules.
Just on that point, and I wonder if this is a good juncture to go back to that issue about the fact that we're not talking about JSMs, joint settlement meetings here, or RTMs, roundtable meetings, with a view to settling claims. We're talking about experienced people who have got training in mediation, and that is not necessarily the person who's running the case. That is an independent third party who is there to assist the parties to find an outcome that suits them. So it's important that that distinction is made, that mediators are trained in mediation. They're not. It's not about saying I'm going to also attempt mediation as well at the same time as running the case.
Absolutely, and obviously lawyers involved in the case can't be an ADR professional for their own clients due to a conflict of interest, but
Correct.
more broadly, solicitors, firms, barristers, chambers, and independent businesses like Hunt ADR are springing up all the time to fill this gap in professional services, because ultimately, as you said, this isn't a roundtable meeting
No.
to informally discuss the case. It's a formal process run by a professional who's been trained in those specific skills to help parties come to an agreement, or in another area like expert determination. And
Yeah.
so that whole industry, all the ADR industries, will really be coming to the forefront as extra professional services on top of your normal legal services. And
Yeah.
we've already seen that with, especially in London, chambers in London and solicitors' firms are now running mediation panels. I sit, for example, at a chambers on their mediation panel, as lots of ADR professionals do. So
Yeah.
the more people understand that ADR is a separate expertise in and of itself with separate training, that's obviously really important. And lawyers, hopefully, though young, newly qualified lawyers will know that, but breaching that across the system will be important in the coming years.
And that's a good point to throw in, that for those listening to this podcast who may be interested in starting a career as a mediator, our next course is on the 11th to the 15th of November. That's 2024. It'll depend when you're listening to this podcast if that's already happened or not. And that course will be led by myself and Kelly, and leads to full Civil Mediation Council accreditation as a mediator. To wrap up, I think I'd like to ask you both, maybe you can answer one of these each, and not in the style of a mediator. I'm going to let you decide rather than tell you which one I'd like you to answer. What you see as the main barrier for this being a success? And then whoever gives the main barrier, can the other person give a view on how that main barrier is actually dealt with, so it's not the main barrier anymore?
I, my feeling about one of the main barriers is people perhaps wrongly assume that mediation is a watered down version, or it's a bit of a chit chat over cups of tea and biscuits about how to resolve things. And there's no real teeth to the end of the process. Nothing can be actually done. You can just walk away if you don't like it, and that's not the case at all. Um, the the resolution or the settlement is in the parties' hands, but it can be turned into a reasonably toothy solution should it need to be. So I think perhaps there's a misunderstanding of what mediation is and what it can achieve. Callie, I hope I haven't dropped you in it by
So
asking
no,
you that.
that's okay. I think also that leads to that wider barrier that we've already mentioned, that people assume it's mandatory mediation or mandatory ADR. And I might be being bold here, but I would suggest the response or the solution to both of those is the same thing, which is primarily education. People
Yeah.
understanding, actually doing some research. So legal professionals doing research on what ADR procedures are available locally, what different experts can offer, whether it's an arbitrator, an expert determination, conciliation, mediation, etc. And also parties being told by judges, being told by their lawyers, being told in that pre-action phase what their options are in detail. And as we've already said, there's lots of mediation companies. Of course, the best is Hunt ADR, but there's lots of mediation companies available who have great websites full of information that explains the processes your mediator will take you through. And as long as ADR professionals are confident in selling their skills and being able to pitch what they offer in terms of dispute resolution, it will filter through. It just takes time. And I think we're at the beginning of that journey. And if you look at jurisdictions like the US, they're a little bit further along the road, but they have a very, very successful ADR sector.
They do. I agree with that. I agree with everything. And it's about trust. Trusting the mediator, trusting and empowering the mediators to help the parties come to a resolution. I certainly would echo everything that Kelly said, and the US example has some very, very good research behind it that it can work. Even the mandated 1 hour mediations, which have been heavily criticized in the past, have been shown to be quite effective at reducing some of the contention between the parties, or at least narrowing the issue so that if they don't settle, then they're only concentrating on one or two things rather than a whole host of issues.
Yeah, and I think it's worth pointing out for listeners who I'm sure will be aware of other jurisdictions, but if they're not, the fact that there are countries that mandate mediation. Italy, quite famously, has gone for mandatory mediation. We're not there yet. We might never be at the point of mandatory mediation, but the ADR and particularly the mediation sectors in these other jurisdictions is well developed. So there's lots of case studies that exist in the world of how this can work. And this, I think, is indications that the UK is moving towards a more inclusive culture of alternative dispute resolution rather than court being your be all and end all, as it were.
Yeah, and I think it's as mediators and as people who've been trained to be civil and commercial mediators, we need to be open-minded, and we need to, I think, welcome what the courts are trying to do. It reminds me of the old famous Star Trek quote: "It's life, Jim, but not as we know it." You know, these 1 hour telephone mediations aren't necessarily what we consider to be fully properly set up commercial mediations, but they are mediations, and it's part of the mediation landscape now that these things exist, and they will lead to other opportunities, I'm sure. So I think we need to just embrace it all, see how it goes, be ready to be proactive and also to react to opportunities that might come up as we move along. I found that really useful. Thank you. I think anyone who, any of our listeners tuning in, will find that of great interest and education. So thank you, Kelly. Thank you, Cam.
Not
Thanks,
at all.
Greg.
And I will see you soon. Thank you for joining me on No Disputing That. If today's discussion sparked your interest, be sure to subscribe, share, and leave a review. For more insights and updates, follow us online or visit our website. Keep learning, keep mediating, and remember, there's no disputing that.